panel on ethics, rights and data management in the digital policing revolution. My name is Professor William Webster. I'm a director of CRISP, and CRISP hosts a panel each year at Cpdp. Previous panels have been on body-worn cameras, the Internet of Bodies and various other topics. For those of you who are not familiar with CRISP, CRISP is a UK research centre based at 4 universities in the UK, Stirling, Edinburgh, St Andrews and Essex, multidisciplinary research centre interested in the consequences and impacts of the surveillance society. We have a great lineup of speakers this morning for you. I've put the list of the speakers on the slide for you because we've had a last-minute withdrawal due to unforeseen circumstances. So the new list of speakers is as presented. I'd like to thank Professor Charles Rabb for joining the panel at very short notice. He hasn't prepared a presentation as such, but he's going to spend a few minutes talking about his role in policing police ethics in the UK. So thanks to Charles for stepping in at quite short notice. Now we have an excellent lineup of speakers. I'm really looking forward to hearing what they have to say on this topic area. And what we're going to do is we're going to run through the different presentations. We have some slides, some presentations are going to just be talks, and then we're going to hand over to Rosamunde who will moderate the session. I'm not going to spend long introducing each speaker with lengthy bios. I've just introduced them by name. They can introduce their own backgrounds and their own research for you. I have been asked to say that during the question and answer session that there is a roving mic, so when you want to input into the debate, please put your hand up and a roving mic will appear. Please introduce yourself by name and then ask your question. So without further ado, I'd like to move on then to our first presentation and our first speaker. And I'll have to find the slides.
Okay, good morning. My name is Fanny Coudert. I work at the EDPS. Today I was asked to talk about the Law Enforcement Directive and in relation to predictive policing. So that's a very broad topic and I only have 10 minutes. So let me start with an example. We see the slide, but that's not so important. So I will start with Tomorrowland. Tomorrowland is a very famous music festival that is taking place every year in Belgium and which gathers around 400,000 music lovers every year. So you can imagine that this is a challenge for Belgian police to ensure security. So for the last edition, Belgian police decided to test something new. They decided to screen the 400,000 ticket holders and the voluntary staff. They matched their personal data against national police database, against the Europol database and Interpol databases. The goal was to define whether any of these persons might pose a risk to public safety during the event. And in case it would have been assessed as posing a risk, the person was to be denied access to the festival perimeter. Okay, so what did they check? In terms of data, the cross-check included not only conviction, but information contained in police reports, in intelligence reports, and information coming from ongoing investigations. How did they proceed for the risk assessment? So it was kind of, they defined a series of criteria. And first they checked whether the person appeared in the database for a series of crimes, such as drugs, radicalism, including terrorism, criminal organizations, etc. Then they filtered on the basis of the dates of the fact for which these people were known. So any facts that happened before 2000 were not taken into account. And the fact that happened between 2000 and 2010 were only taken into account if the person would also appear in the database for facts that happened after 2010. And then the third step was to, on the basis of the list of people, they discarded people who appeared only once, and people mentioned intelligence reports older than 5 years. Okay, so what the result was that 27% were denied access to the festival. And this person were told that if they disagree with the decision, they could appeal to the Belgian Privacy Commission, which is a bit strange, as they were not involved in the process. So many people appealed to the Belgian Privacy Commission. People went to challenge the decision to the courts as well. And what happened is that both the Belgian Privacy Commission and Cpdp, which is the supervisory committee from the Parliament of Police in Belgium, and they both decided to open an inquiry to know what happened. And what they found out that many things went wrong, actually. First, not all people were screened, because people for which a friend or a company bought a ticket were not screened because they were not identified, at least at the moment where the data was sent to the police. The second finding was the criteria of the screening were not correctly applied. Actually, the Cpdp went there and redid the process step by step, applying the same criteria, and they arrived at the conclusion that only 5 people should have been denied access to the festival instead of the 27 people. And even in the case of the people who appealed or challenged the decision, and in that case the police redid the process and the scoring process, but even in that case they could find mistakes. There was a problem with the quality of the screening process. A third problem that the police, in case of a hit, so before deciding to exclude someone, to refuse entry to this person, they did not review manually the hits, in the sense that they didn't go to the police report or to the intelligence report to make sure that the fact for which this person was known was actually relevant for the screening. And finally, the criteria that were used were not linked to prior security risk analysis. So the police did carry a security risk analysis, but in parallel to the screening process, there was no link. So the risks identified were not taken into account to define the screening process, the criteria, for instance. So I think this is a good example of the challenge ahead when implementing new digital policing practices. And they didn't use algorithm. But what do I want to show you with this example? Let's move to the first, that what new policing practice means in terms of data management. So it means first increased data exchanges between private sector and the public sector, between national police and Europol and Interpol. So what this means, that this is leading to a progressive interoperability of databases, because you need to be able to check in different databases if this person is known in that case. This could also lead to the merging of different databases in order to ease the process. So this is, for instance, what is happening with Europol under the new Europol regulation. If you read the European Commission impact assessment, you see that one of the goals of this regulation is to set a legal framework that would allow Europol to merge, to create a common repository in order to apply new technology and deliver more efficient intelligence. So the next step, obviously, and the problem will be, I think this has been largely mentioned in the other panel, is the use of algorithm and the challenge they raise in terms of risk to privacy. So my second point with this example was to give you some examples of the risk to privacy that these new policing practices are posing. So first, function creep, because we are fostering a reuse of the data for other purposes than the one that initially motivated the data collection. Second risk is the decision making is more opaque. In that case, as the police did not use algorithm or sophisticated technology, the supervisory committee were able to go back and redo the whole process. But obviously, the next step will be for police to automate this kind of processing, and this will become, maybe it will not be always possible to have access to the criteria defined, especially when you use specific type of algorithm. And this leads me to the third risk, which is the risk of unfair processing of biased processes, which is not easily detected. Okay, so coming back to the question that was asked me to answer, that does the Law Enforcement Directive give us a legal tool to adequately frame these practices? As you know, member states should transpose this directive, which was adopted last year together with the GDPR, by the 6th of May. And this is the first time that we have an instrument at EU level which regulates national data processing authorities by law enforcement. I would like to point two aspects. So the Law Enforcement Directive contains some material safeguards which enables data sharing and cross-check if necessary and proportionate. That's so it means that law enforcement, the directive recognizes the needs of law enforcement to reuse the data collected with one context beyond the context of collection, in order to make links between different criminal offenses, and it's said explicitly in the directive. With this new requirement, with this requirement that this should be necessary and proportionate, but we don't have more information on how to interpret this broad concept. Another material safeguard is a regulation of automatic decision making. So this refers to decision which produces an adverse effect on data subject. So I think that's the example of Tomorrowland is one example of this kind of processing. And what the directive says here is that you can do it, but you have to implement a series of safeguards, and the directive gives some examples, which is the right to obtain human intervention on the part of a controller, so in that case a law enforcement authority, the prohibition to base a profiling on sensitive data, the obligation to provide sufficient information to the data subject, to hear the point of view of the data subject, so it has to be contradictory, the obligation to give an explanation also of the data subject, which is not the case here, because people were only informed that they will review the entry and full stop. And also to allow data subject to challenge this kind of decision, to have remedies in place. So we can see with this example of Tomorrowland that these basic safeguards, which seems quite obvious, were far from being implemented, so they don't come as a given. There's still quite a lot of work to do. So this brings me to the second kind of instrument that law enforcement is giving it, which are procedural safeguards. And what I think is that the Law Enforcement Directive organized a new accountability schemes which we will have to leverage somehow. You have the provision on accountability, Article 19, where law enforcement authority have to implement technical and organizational measures to be able to demonstrate compliance with the directive. You have the provision on data protection by design, when they develop new technology to take into account privacy from the start, on a new obligation to perform data protection impact assessment. Thus to assess the rights posed to the risk posed to the right and freedom and define mitigation measure. And in the example of Tomorrowland, I think this would have forced police officers to base the screening on a security risk analysis to assess whether the screening was proportionate and able to achieve the goal. To assess also which criteria should have been used, if they were necessary and proportionate, which database should have been used to do the cross-check, and this would have forced law enforcement to clearly spell out how to organize information to the data subject, to implement a review process of the decisions in case it would be challenged by data subject. And another provision contained in the Law Enforcement Directive is a need for prior consultation with data supervisory authority for high-risk data protection operation. And in my opinion, this would apply to processing such as the one of Tomorrowland. To conclude, I think that the Law Enforcement Directive enables, rather than restrict, new digital policing practices. It frames these activities by requiring police authority to carefully think about their impact on the right and freedom of individual. But my key message today would be that actually the Law Enforcement Directive creates new opportunities and challenges for supervision. And I think that's a key provision, because supervisory authority are given a new role as advisor through the prior consultation, in addition to new enforcement power. So this is maybe a new relationship that should be built and maybe taken advantage of. Thank you.
Thank you very much. As I think mentioned, I'm sort of parachuted in almost at the last minute because our colleague Pete Fussey is unable to come. And I'm Charles Rabb. I'm Fussey, but not Pete Fussey. And one reason why I was thought appropriate to come and speak at this panel, although very briefly, is in my role as the co-chair. Well, first of all, I'm one of the directors of CRISP, so I have a moral obligation to step in when somebody is not able to come. But also, I'm in the UK. I'm the co-chairman of a thing called IDEP, which is the Independent Digital Ethics Panel for Policing. And since I don't know anything about policing or about ethics, I'm the correct person to be the co-chair. Let me tell you a little bit about IDEP. And it was set up a couple of years ago with the support and the encouragement of the National Police Chiefs Council in the UK. There are 16 members of IDEP, and one of the other speakers, Hadjimatheou, is one of the members. There are people who come from the world of ethical philosophy. I'm a political scientist, social scientist, who's worked on data protection for a long time. We have some senior police officers. We have somebody from the National Crime Agency and a few others from industry and the law. And what we were set up 2 or so years ago for the following reasons. The police are increasingly using digital sources of evidence in their work. And they've come up against, at least at certain levels, dilemmas. Not dilemmas about what they can do legally and what they can't do legally, because they know what the law says more or less, even though the law may be fairly vague in some cases. But what, above and beyond the law, there are the ethical questions. Should they be doing things that, even though they may be legally entitled to, should they be doing them? Do these cut against the bone of ethical principles? And the police like to say that they are based upon principle-based law enforcement, going back to 1829 with Sir Robert Peel's famous famous principles of policing. But now in the digital age, so-called, these are not particularly completely relevant in any detail. So they're interested in having ethical advice on projects and things that they're proposing to do using digital sources of data. And also they're looking for some kind of high-level, overarching guidelines and principles, and therefore IDEP might be in a position to do this. So we have these 2 modes of work. One is to develop high-level ethical principles for law enforcement, and not so much rules, but things that would inject ethical ways of handling ethical dilemmas. but also, and we've been particularly active in the last year, in advising and producing opinions for organizations within the law enforcement world concerning projects that they are developing or have been wanting to do. And since there's a big push for digital policing in the UK, as I suppose everywhere else, these are becoming more and more palpable issues, and there's beginning to be a queue forming to get ethical advice and get opinions from IDEP. We may not be able to satisfy the people in the queue, but at least we want to put ourselves on the map as a place to come where we can give that kind of advice. I'm not at liberty to say exactly what advice we have given to whom and for what over the last year, but pretty soon we should be able to go public with all of that. One thing that could be said, for example, is that advice has been given to the National Crime Agency for their work on undercover online policing. So it's that kind of thing. There may be other projects that other organizations might want advice on concerning predictive policing, which is becoming increasingly popular and controversial, or on the merging of databases within the law enforcement world. And possibly further down the road, some work that we might be involved with, I don't know yet, in the area of biometrics and forensics, because there is a biometrics and forensics ethics group in the Home Office, or under the auspices of the Home Office, and we've been in touch with them for some kind of possible liaison for further activity. So that, in a nutshell, is what IDEP does. And as I say, it's early days. We have a website, but if I were you, I wouldn't treat it as a source of knowledge or wisdom, because at the moment it is very, very underdeveloped, and we hope to improve this pretty soon. So without any further ado, I think I'll stop there. I'm willing to answer any relevant questions about that.
Hello? Is that? Yes. Hi, everybody. I'll just introduce myself while the slides come up. My name is Hadjimatheou. I am a researcher at the University of Warwick in the UK. My background is in moral philosophy, but in recent years, my work has focused really on security ethics, criminal justice ethics, and how the use of technologies feature in those kinds of debates. And I sit with Charles on the independent digital ethics panel for policing in the UK as well. I'm going to talk to you today a little bit about some research that I'm doing that is emerging from an EU-funded project. This project brings together ethics people like me, technology specialists, and police to consider some of the ethical, legal, and other issues that arise around the use of social media by police, local authorities, and other security providers. Now, Charles mentioned somebody called Sir Robert Peel. You may not have heard of this person, but he is in the UK known as the father of British policing, and he has been for the last 200 years, which was when he was Home Secretary, and he devised these, I think, 16 principles of policing. These principles have come to define the British approach to policing, and they still do today. And one of the challenges that policing as a service finds itself faced with today in the UK is how to make these principles make sense in the modern digital age. One of these principles says that the police is the public and the public is the police. The only difference between the police and the public is that the police are paid to devote themselves full time to the pursuit of a public mission and public duties, which are in fact incumbent on all of us. This was something that Sir Robert Peel felt very strongly he needed to articulate, partly because he was introducing the first official formal police force for London at the time, and there had been a not so pleasant recent experience in France with a similar experiment. So he articulated this principle to reassure people that the police are just like you and me. They're just spending their whole time keeping us safe because we're too busy and perhaps it's dangerous to do so. I mention this principle, I hadn't planned to, but Charles just reminded me of it, because there is a drive in Europe, especially in the UK and in the Netherlands at the moment, to responsibilize. It's a horrible, horrible word, but that's the word that's being bandied about. To responsibilize citizens. What does that mean? It means to encourage them to take responsibility for their own security. And the last 10 years of public austerity, economic austerity, has really driven this. The police do not have the resources to meet public expectations of crime. Public needs to step up, take responsibility, remember that the police are the public and the public are the police, and start taking care of their own communities. Now, what I'd like to talk about today is what's happening in this sphere, because the public are stepping up, and digital policing isn't just done by the police. It's increasingly being done by members of the public. And what I'm going to talk about today is just give you really a flavor of what's happening in this field, give you some examples, think about some of the benefits, and think about some of the risks. Now, in this project, we've called this sort of new movement in citizen-led security DIY policing, that is, do-it-yourself policing. Where is my stick? So I'll just give you a brief outline. I'm just going to say what DIY policing is, what I think some of the emerging implications are for policing, the way policing is done, and for democracy, and what should the police be doing about this new wave? How should they engage with these groups, if at all? So just some examples. At the top, I think at the top left there, you'll see something you may be familiar with. Next door, this is a kind of social network for people who live in a particular area, deals with lots of different things, questions, sharing of information, but also sharing of information about crime, how to prevent crime in a local area. So here, this is a bit like Neighbourhood Watch, but it doesn't involve police at all. It's proactive, self-started, and supported by a technology platform. Below that, you have an example you're probably familiar with. Is this the Boston bomber, is what is written there. This is an example where, following the Boston bombing attack in America, online there was a kind of spontaneous campaign to try and crowdsource an identification of the bomber. So this is people doing investigative work that police would be doing online with not very positive results in this case, because somebody was wrongly identified and they have since died in mysterious circumstances. At the bottom you have the police policing the police, the public policing the police. This is something that we're increasingly seeing digital technologies being used to do. And on top of that is one phenomenon I'm really going to be focusing on today, because I think it's very interesting and it raises serious questions for policing. This is the increasing prevalence of online predator catchers. These are people, citizens like you and me, who go online. They go onto chat rooms, Facebook, other chat rooms too. They pretend to be children and they engage in conversation with people online about becoming friends. They wait for these people to suggest maybe sexual sharing of images, engaging in sexual talk, and eventually arranging to meet, which is illegal in the UK, at which point they collect the evidence of this chat log online, they meet the person, sometimes they video it and just use it as a chance to name and shame the person online, but increasingly they perform a citizen's arrest and call the police. And I think this is really interesting, not least because in 2016, 46% of grooming cases in the courts involved evidence from these groups. So their impact on the kind of cases that are being brought to court, the kind of where policing and criminal justice resources are going is pretty transformative in this area of child sexual exploitation and offences online. So they're worth looking at for that reason. Very quickly, what are the general drivers of these groups? Firstly, gaps. I've already talked about lack of resources. In many cases, crime is too low level. The kind of crime that they work to investigate or detect is too low level for police to prioritize. This goes for child sexual exploitation too, because the police are very, very strapped for time. They generally do not pursue cases where the child is 13 years old or over. And yet, we see these predator-catching groups starting their conversations typically by saying they're 19 years old. Then as the friendship develops, saying, actually, I'm 14. So they are really going for the low-hanging fruit, these predator-catching groups, crimes that police wouldn't be prioritizing. There are organizational constraints that these groups also move in to fill. Resources, skills, being digitally skilled. Many of these organizations are very good at using digital investigation techniques when police forces are not. Also, they can bypass legal constraints. For example, in the UK, entrapment law means police are very constrained about what they can do when they engage with people in chats online. Members of the public are not constrained in this way. They are also taking advantage of technological opportunities. For example, platforms are being engineered currently specifically for certain kinds of security problems. And again, in the field of child sexual exploitation, a Dutch charity engineered an avatar, which they then used in video to speak to people online. So technology means that specific security problems can be addressed quite precisely. Also, security initiatives can piggyback on trusted platforms like Facebook, like Twitter, like Reddit. They're very good at using crowdsourcing. They take advantage of anonymity and encryption. Again, you see that in the case of predator catchers. You can't see who they are. They could be anybody, and they are just about anybody. And also, they can take advantage of the cross-border reach of the internet to crowdsource information, for example, where police are constrained in that way. What are the potential benefits of this new movement? Well, quite obviously, you can address certain security gaps without extra pressure on police resources. That's surely a good thing. There's a potential to harness flexibility, adaptivity, and responsiveness of these self-starters, these tech whizzes. There is also, I think, a potential to build increased trust and legitimacy in police if they interact effectively with these groups. And there's a potential to foster a more active citizenship. This is very much emphasized in the literature around responsibilizing citizens, getting citizens to participate in security for the benefit of all, getting them to take responsibility. This is surely good for democracy and social cohesion. But does DIY policing really mean democratization of policing in a good way? What do we mean by democratization? Is it just the public doing policing? Doing policing for whom? And how can we make sure they're really doing it for the public? How can they claim, with what authority can they claim to be doing it in the name of the public, which often they do? There's often a questionable mandate. Who is the community that is being represented, but whose security interests are being represented by these people? How do they consent? In the case of predator catchers, their activities are diverting resources that could be used to chase contact offenders who are targeting small children. These resources are being diverted to people who are trying to meet 14-year-olds. Often we don't even know if they're actually a contact offender. There's a lack of accountability. Who is scrutinizing these people's actions and making sure they are fair? There's a real risk of unjust citizen interventions. And again, we see with these predator catchers, often they publicize online their meeting with these people, and sometimes they meet them in their houses, and their families are there, their children are in front, their wives are in front. This is put online. Doesn't seem to be a particularly well thought through and proportionate approach to these kinds of crimes. And as I've already mentioned, there is a potential to undermine police priorities, but also to undermine investigations. If the police are after somebody who is a contact offender and they are amassing evidence against this person, and a predator catcher comes and exposes them, this person may go underground. They may warn other people to go underground. People might be hurt and investigations might be compromised. Also, there's a risk more generally, not just with predator catchers, that there becomes an overburdening of police with data. A lot of these groups, interestingly, I think, rely on the existence of strong and legitimate police and criminal justice systems in order to do their work. They refer up. Eventually, they collect their data, they do their work, and then they hand it over to the authorities to do it right. But that handing over process is burdensome to the authorities. What do we do if the expectations can't be fulfilled? Okay, and finally, just a question really about what the police approach to this DIY policing should be. In the UK, we're really in a conflicted moment right now. We have been told by some of these predator catcher groups that the police say, thank you very much, don't do it again. I think that's an incoherent and unsustainable policy. You have to find a way to engage with these groups, otherwise policing really will be displaced. So rather than that, I would propose, let's help you to help us. Thank you very much.
Right, excellent. Well, I think maybe just on my end to speak a little bit about some of the challenges, also to pick up on what Fanny said, in why are the police looking in this direction, just in case not everyone is fully updated on the challenges that we face. But it's a number of different parameters, basically. It's both, most fundamentally, obviously, crime has changed in the last probably 10 years significantly. We are seeing not just what you would call traditional cybercrime, obviously, where someone is hacking computers or accessing data overline. It's also that numerous types of crimes now only take place online. You could say it's not exclusively the case that no one robs the banks anymore, but the smart criminals have figured out that the number of risks you expose yourself to if you try to stake out a bank, plan your escape route, you get a gun, you find a mask, you get in, you get video surveillance, you have to get away before the police find you, you leave a ton of physical evidence, DNA, we might even be able to identify you on the way you move. There's a ton of different risks involved in committing some more traditional forms of crime, but obviously if you can access a bank or online and do a credential theft or in some way gain access to these money to the bank and then commit the same crime basically using cyber tools or the internet, whatever the case may be, that is obviously a much lower risk you're running, and then also just new forms of crime that you wouldn't have heard of before. Obviously, the distribution of child pornography previously used to be a very manual exercise. Now it can be some fun where someone is actually online, specifically ordering, paying for someone to assault a child somewhere else in the world, and that just creates new forms of crime that are international, that raises jurisdictional issues. It complicates a lot of the tasks that police are charged with. Obviously, also there's obviously a public expectation that police responds to these new threats. So if more and more citizens are faced with identity theft or their banks bank accounts being compromised, whatever the case may be, e-trade, where people are ordering goods in someone else's name, they of course expect police to be able to respond to these new forms of crime. So that's both a political demand and obviously a legitimate expectation from the public. And then, of course, also organized crime has become increasingly international and, if you will, professional. And that means that the overview and the understanding of what the police needs to confront is just much more complex than it was 10, 15, 20 years ago. And basically what we're seeing is, of course, as society becomes digital and moves online, and we all have smartphones, and the criminals move in the same way. They go where the individuals are, where the resources are, where the money are, and the police needs to follow. So that's sort of the basic challenge that is driving this subsequent change in the way policing works. And I think from a data protection point of view, I think something like the Tomorrowland case that Fanny mentioned I think it's very interesting. I mean, I would say that it's important in a case like that where you decide, okay, let's screen 400,000 ticket holders at a music festival in order to ascertain whether someone poses a significant security threat. Fundamentally speaking, from a data protection viewpoint, I would say that is a legitimate purpose. That is something that should be justified under law. I would, as a lawyer, have no problem finding the processing basis, if you will, the legal grounds for doing that exercise. But what I think is also correct in what Fanny says is that obviously what becomes very important then is that the process that you go through, the purpose that you outline before you do it. So in order to avoid some of the risks that Fanny also mentioned about purpose creep, you need to be very clear beforehand, before you set out on what is the purpose of what we're doing here. And I think that's a real risk in embedding that in police organizations going forward, because technology will give you all these tools, will make you available to the average police officer, and making sure that when they set out on these types of investigative or preventive measures, that this is done in accordance with sort of a fully thought out due diligence process, if you will. I think that's what the Data Protection Directive, the LIA directive, is trying to do. In practice, I think it's important to recognize that this is just like using these tools is a culture shift. Having to think in these ways is also a culture shift for police organizations. We're not necessarily familiar with. It's almost like an IT project you have to think about. You're not used to going through these motions. We have more traditional ways of doing things, like saying, do we need to have a court order to search a premises of or a car or a person? That's the traditional paradigm for a law enforcement officer, where the digital realm was saying, well, this is just, it's data. The festival are free to give it to us. They gave it to us freely. We didn't force them. We didn't need a court order. Why can't we just search for whatever might be relevant for us to know and then do the assessment? So I think that's going to be maybe a common starting point for a police officer. So how do you embed the understanding of the risks that this entail without having to go through the actual learning experience with all the consequences that might have for citizens? I think that is probably one of the interesting things looking forward. How do we train police officers and make this function in real life? I mean, it might be easy for a data protection lawyer to understand what a data protection impact assessment, at least in theory and maybe also in practice, should contain. But in practice, for law enforcement officer, this will very often not be the case. Just it's not their paradigm of thought. So I think that's just to flag that's one of the issues that I see going forward. Well, that was actually it.
Okay, thank you.
Hi, my name is Rosamunde van Brakel from the Vrije Universiteit Brussel, and I will be moderating the questions today. So I don't know if there's anyone already with a question for our panel. There's a microphone coming. Anyone? I'll start off with a question for the panel. My question is, does law enforcement have sufficient resources to put in place the safeguards that are taken up in the Law Enforcement Directive? And my second question is, if there are the resources and all safeguards are put in place and implemented, are they sufficient to deal with all the new developments going on, such as predictive policing, such as what Kat was explaining about the citizen policing? I don't know who wants to start responding.
I'll be able to try, and then pass it on to Kat. Okay. Well, I think the easy answer is in regards to all the tasks that we're faced with. We are, I think, police is generally overburdened. So the answer is probably no. And so this will be something that will be have to be done in a prioritized way, in regards to also keeping in mind that there are also a lot of other laws that we need to comply with, a lot of tasks that have been put upon police. But I think there's also recognition as we start utilizing more and more of these tools and these methods and using data in a new way, it should go hand in hand. Whether or not the safeguards that are created are sufficient, I think that will be something that will be a work in progress. And we will have to see as we go along. I think it definitely sets a good framework, but it's something that's going to have to be continuously refined as we go along. It's not. I don't think we have the blueprint for the final layout of what we need to go through as a process. But something like privacy by design principles and data protection impact assessments definitely sets the scene, if you will, for the right thinking, and then we're going to have to do some learning by doing, I think, in practice.
In terms of resources, I think there's a real issue with resources. In the UK right now, the majority of police work, officers that is, who are out and about, is not dealing with crime. It's dealing with, and I'm not exaggerating. I mean, crime is rising, but increasingly research is showing that the vast majority of officer time is spent dealing with people's social problems, mental health problems, not actually dealing with crime. And this is part of the reason why there's a drive to engage citizens, because this is the kind of stuff communities ideally should be able to cope with and absorb and not have to call the police to deal with. I mean, the regulation itself, I think, is good. It's a good way forward. If the police can bring into the fold those people that can really help them address these other issues, so that they too become respectful of this legislation, that would be good. But I think that requires a bit of a mindset change from the police as well, of not just telling people what to do and always leading, but recognizing that citizens will they don't want to be dictated to by the police. So it's going to be, I think it's going to be tricky to see how that engagement can work. Hopefully it can.
Rosamunde's question is about, do law enforcement organizations have the resources to put the safeguards in place? And one thing that I've observed, I think we've observed in the independent panel, is that law enforcement organizations know certain things that they have to do which may be resource intensive. That is to say, a lot of people might be involved in them. Things like privacy impact assessments. And that's one of the first things that they turn to, and quite rightly, I suppose, in developing new projects. Now that's resource intensive. It takes certain kinds of skills. It's not simply a checkbox sort of thing, or it ought not to be. And that depends upon the expertise that they have. Now there's a lot of money around in the UK through what's called the Digital Innovation Portfolio or something like that, which will fund projects that law enforcement organizations want to do. And I think that I would expect that the resources for developing the safeguards and developing the in-house expertise in a particular law enforcement organization, a police force, let's say, would be available through that the funds from that kind of portfolio. But that said, there's a risk that there are good and bad PIAs, mostly bad PIAs out there in the world, and it's a question of how to develop the resources to improve that and to make it less than a kind of perfunctory review with you tick boxes and so on. That may be very difficult. So I think bringing those safeguards to bear and finding the money and the expertise and the time to do that, I think is going to be a real issue. Can I say something about in the long run? I think in the long run, one of the most efficacious things that could happen is if knowledge and familiarity with ethics and with the social implications of policing were to be more firm in the digital age, were to be more firmly built into the training of police officers when they're young, before they go out there on the beat or before they go behind a desk and look at monitors and so forth. And the question there is how far that can be built into the curriculum and the training that police recruits get. I think this is in the long run, I think ideally what ought to happen. And perhaps panels like ours can begin to push and see whether the door is open to do that. And that, in a sense, in the long term, would raise the possibility of better safeguards in the future.
We just add something. It's not only actually a question for law enforcement, the problem of resources. I think it's also a question for supervisory authorities, because we are relying each time more on procedural safeguards to apply the law, because reality becomes more complex. But this also requires a lot on supervisory authorities, and they don't have that many resources. So I think we should move towards a new way of collaborating and of working on both sides, actually.
I just want to, okay, there's a question. The mic.
Thank you. I've sort of a chicken and the egg question. I thought it was interesting that Kat mentioned social media usage by law enforcement, because I think that's a perfect example of one of the challenges for law enforcement, for the private sector, is sort of, and for all digital policing issues is, or a lot of them is, there are not established societal norms about how we interact with these things. You know, and people, if you took a survey of a room full of people about access to social media, some people would say it's completely open source. The point of Twitter is to communicate, so of course government and police are going to read it. Some people would say, you know, there are different, you know, everybody behaves differently on it, so how do you, it's not fair to analyze this in certain ways, and there's sort of this spectrum of understanding. Is it, and so when you know, advocates and others go to law enforcement and say, you have to behave a certain way with this technology, they say, but you can't agree on what that is. So I guess my sort of convoluted question is, what do we need to do first? What's the framework for actually being able to provide ethical advice, to be able to say this is what should be done? Is it up to society to get more established on sort of norms for digital mediums, or is it law enforcement should make a statement and then everybody reacts to it, and then you figure that maybe that pushes the establishment of norms, or is there an interim? Law enforcement behaves until things get settled. Law enforcement behaves a certain way towards digital platforms, and then as time develops, then that will change. Does anybody have a sense of what the best framework is for approaching this uncertainty?
I'd like to respond to that. I actually think that law enforcement need to be much more proactive about moving into the public space in this area and defining the agenda. I think they're too reactive to civil liberties organisations. Civil liberties organisations, some of whom have nothing to lose by just pointing the finger at police, and often their friends will all agree with them, it's an easy target. The police respond by being defensive and saying, wheeling out the same kinds of predictable statements, we're here to protect everybody, don't you want to be safer, don't you want us to lock up the bad guys? And it's predictable tropes, we don't get anywhere. So I agree with Charles. Ethics needs to be in-house, something that police do, and they do it first. So that just like we have medical ethics committees, just like we trust doctors to be the first ones to have thought of the ethical issues when it comes to operations, when it comes to decisions about life and death, we should have the same expectations of police. And police need to, I think, be much more confident. I think there are lots of reasons why they're not, one of which is the very hierarchical structure of police organizations, which does not encourage or nurture critical thinking, discussion, which is absolutely necessary if you're going to talk about right and wrong. Too often it's just, you'll do that, why? Because I said so. That's what I see happening, even in quite progressive police forces. But I also think that, so I say this, how should police start? I think we work back from what police are for. Police, and there's debate about that, of course, especially in the philosophy field, but police are there to at least try and prevent crime. And so if we start from that, we at least have a reason why certain things, like just speculatively browsing through social media on green, let's say environmentalist activist website, you have to have a clear policing purpose that is being served by something. I think that's a very general thing to say, but that's the general methodology. You start with what we're authorized to do, and from that backwards, you see, is there really a justification in that mission for what I'm about to do right now online? That would be my penny's worth.
Thanks very much. I have two remarks to make, and this is not in any sense to pick an argument with Kat. I certainly wouldn't. But if the police say, we're there to prevent crime and we're there to keep the public safe, then that immediately raises questions, well, how far can you go? And this is the ethical question. How far can you go to prevent crime? How far are certain kinds of predictive policing techniques legitimate, not just legal, but legitimate and ethically responsible? And so immediately you're thrust into it. And sometimes I think I agree with you that the police are put on the back foot and they respond by saying, we're there to keep you safe, just like doctors are there to keep you healthy. But that avoids a lot of the wicked questions. But the other thing is, let's look at the climate, and here I'm speaking not with any academic expertise, but just as somebody who watches news on television and reads newspapers. Look at the climate within which crime and punishment are brought to the attention of the public vicariously. Okay, you might see somebody being mugged down the street, but most people have never been mugged or seen anybody being mugged, but you read the newspapers, the first thing, at least on the British news broadcast, is, so-and-so was murdered, and here's a picture of the police cordoning off the house and whatnot. And that kind of thing, and the commentary about it, serial rapist let go on parole, blah, blah, blah. I'm not judging one way or another in that kind of case, but that's the climate of discourse that you get in the media, which I would imagine shapes public opinion about it, and it's within that climate of public opinion that both the police operate and also the civil liberties groups operate on the other side. So maybe what we should have in the next panel on this subject are some journalists and ask them how they cover some crime journalists or people on Crime Watch on television broadcasts in the UK. How do you cover these things? Why do you give them so much prominence? Why do you write the stuff you do? And what comes back from feedback on the public response to all of that? We always forget the role of the media in any of these discussions at this conference or at most other conferences that I go to in this area. The media are crucially important in shaping the agendas and in defining the issues, and sometimes in pointing towards solutions.
Anyone? There's a question, and there's one too. We'll go first there, and then.
Thank you very much. My name is Joanna Kulesha. I'm an academic. I deal in international law and cybersecurity. I'm just coming into Cpdp from the French International Cybersecurity Forum. And one of the threads there that I see in a way reflected in this panel, and I apologize if the question takes the discussion too far, but luckily for us, this is not a strictly legal debate, rather an ethical one. So I'll put the question into the pool, and I'm looking forward to your general observations and responses. So the cybersecurity debate seems to be focused in the US on an act that has a lovely acronym that's ACDC, and it deals with legal hackbacks, right? So this is the question where a company is being hacked, and rather than going to the police, which has a very limited scope of actions, hacks back, right? And that's what the US, well, one would say business lobby argues is the only effective method that we have at hand right now. Because the police, as we've said here, is limited by laws. When you mentioned civil justice, in a sense, people fending against sexual predators, etc., that's a thought that initially came to my mind, because the ACDC Act, or proposal, draft, if you will, seems to legitimize that very line of thinking. Now, coming from an international background, as already said, I have no doubt that that's completely illegal. This is not the path we should take, right? An eye for an eye was one of the reasons why we came up with institutional justice. We don't revenge ourselves. We go to the police and we hope that they, thank you, I'm almost finishing up, that they will do it for us. So I'm wondering, what are your approaches? This is not a personal data issue. This is about companies and business compliance and professional security in a sense. But I'm wondering, what are your reflections on that, on hackbacks, company hackbacks, the US debate, the US discussion, or businesses saying, well, police is ineffective, states are ineffective, we'll do it ourselves. I'll be happy to just hear your general reflections. Thank you.
Thanks. Yes, I think that this is a very interesting area, not only because companies have lots of reasons for doing it themselves, not just that the police are slow, but that they often don't want to alert competitors to the fact that they've been subject to these kinds of breaches. And that is a problem, because the sharing of information about these kinds of breaches is quite important to developing strategies to prevent and disrupt them. But I think it is a question police forces need to think about very much, because there are some clear ethical benefits to using these kinds of techniques. We look at, for example, dark markets on the dark web. So you have markets where people are buying and selling lots of perfectly legitimate stuff, but also loads and loads and loads of drugs. And it's very difficult to police this kind of thing. It is doing harm. Now, if the police were to use some disruptive techniques, like, for example, DDS, so overwhelming certain of these sites or certain of these sellers with orders for certain kinds of drugs. This seems to me, from a purely ethical perspective, quite an attractive strategy, because you're not criminalizing anybody. You're not actually interfering in anybody's meaningful freedom, because it's not something they're free to do, to sell drugs, but neither are you kind of criminalizing the drug buyer. Nobody's being having their privacy intruded. The bad stuff stops happening. Relatively low cost, it would seem, in terms of people's rights. And yet these kinds of things are not used yet. So I do think the use of unorthodox techniques is something that we should be thinking and talking about more.
Okay, I see just one more question and then we wrap up.
That would be probably me. Wow, okay. So full disclosure, I'm a novice to the subject, so I find this fascinating because I don't work on it day in and day out. But I was fascinated by the fact that Kat has a lot of opinions on what's right and what's not right and what could be done. And then we have Christian, who is a part of the Danish National Police Force, right? So I'm thinking, to what extent is it practically feasible to come up with cutting-edge thinking pilot projects? So you don't change the society at once, you don't restructure the international collaboration at once, but bring a couple of people together and come up with something that's smart, cutting edge and innovative, apply it in a very small area, and prove that something can actually work. So take it away from that very philosophical, academic, lawyerly debate and come up with a tiny pilot that actually works. So next year or the year after, when you come to a conference, you say, this is what it means in practical terms. So it comes closer to people like me who are a practitioner. Because my job is to take all of this philosophy, come to a corporation or an international organization and make it work on some sort of a meaningful level. So I'd be curious to hear from the two of you especially whether this is feasible. could you actually, is this something that is doable? Can you think of small pilots where you can actually start moving this forward? Thank you.
Well, sure, why not? I mean, I think it's mainly going to be a question of resources, but if it's something that we do a public-private partnership or something that outreach to a research organization, sure, why not? I mean, definitely you can have a dialogue. Resources is going to be the key matter. I think prioritizing it within an organization like ours could definitely be done. It would take some time probably, but I think something like that is already happening a lot on the cyber area, cybersecurity area. People are trying to think outside of the box, but I think it could be really useful. So in principle, I don't see a reason why not. Yeah, well, I mean, not in my organization. I don't think if someone came to us with a proposal or an outline for something like that, it wouldn't be rejected out of hand. I think it would be a question of who has the time, who could do it, and who would be the right people to engage. So it'd all be down to what was pitched, if you will.
Yeah, I think resources is a massive issue. So who's going to pay for this? Basically, that's what we mean by resources. But also, I think an issue with you have to have somebody in the relevant police force, or you have to find somebody who's willing to take a risk. And that's not so easy to do, I don't think. It's especially not easy to do if you're an academic and you have to publish papers in order to keep your job. Because what goes into those papers, and how do you explain to the police what you are and are not going to put into those papers? When it might be operational matters, it might reflect on their effectiveness, it might reflect on their ways of working. That kind of relationship of trust is not always easy to build. So I think that there are barriers, but that's why, for example, the panel that Charles and I work on is somewhere that police in the UK can go to for advice about confidential issues, or working through scenarios, not just advice, working through scenarios on confidential issues in an environment that's safe and we can speak frankly. Unfortunately, we can't use that in our academic work, but there are small moves towards that, and I think we would all want it to happen, but there are still barriers.
Just a quick thing. Thank you for reminding the academics that we live in a real world. We ought to get way off the platform. Just a couple of remarks on that. I think Kat summed that up very well there. And it seemed to me that, I'm not sure this is what you want, but take the high-level guidance that our panel in the UK has developed, and Kat contributed wonderfully to it. And among the things there, which are kind of guidance, is that one has to look to make decisions about necessity and proportionality of the things that you want to do in policing. Now that's an old chestnut, necessity and proportionality, and it comes from the law, it comes from philosophy, and so on. But if we can get law enforcement agencies to think, how can they make those judgments? What does it mean to judge proportionality and to judge necessity when you are a vested interest in the outcome? And whether we can develop not only techniques, but also machinery, organizations, oversight, scrutiny, whatever, so that those kinds of judgments can be placed on a more reasoned basis and a more transparent basis. And I think that maybe our high-level guidance and other things that are happening elsewhere, we're not the only panel in the globe, might be things that you're looking for, practical ways of defining and justifying what you mean by this is necessary to do, this is proportionate to do. And that goes right across the whole field, not just of policing, but also in terms of counterterrorism.
Thank you, Charles. Thank you for coming. This is the end of the panel. Thank you to William for organizing this panel. And I wish you enjoy your lunch.